Ladies and gentlemen, could you please take your seats? We are about to start. Ladies and gentlemen, dear participants, we will move forward with our conference. We will move to the 7th and last session of the conference when we are dealing with the matter of what are the best interests of the child in the adoption procedure. The session is entitled Towards a European Adoption Policy. Actually, we have discussed already both national, international and also European in a sense, because we have to give all full credit to the Council of Europe being a European adoption policy. Maybe this last session will look at a bit more on the situation in the European Union as a specific area of the Council of Europe member states. We will have 4 presentations, but just before we start, I will make one housekeeping announcement. Please check your transfers to the station, airport or city centre afterwards outside of the room. There has been lists of the transfers after the conference to the station, railway station, airport and city centre, and to the Hilton Hotel. So the information is outside. We intend to finish this afternoon by 4:15. So this is our time schedule. It is for the reasons of transport and for the also reasons of our interpreters, who will finish at 4:15. So the discussions will be over that time. So this is already information in advance on the time schedule. But then we'll go to the speakers of the panel, and each of them has 10 minutes to present their intervention, so that we would allow a couple of minutes of common discussion afterwards. We are starting by Mrs. Claire Gibault, who is the former member of the European Parliament, was representing France at that time, and she has the theme of thinking ahead of a present situation. Is a European adoption policy desirable? And the floor is yours, Mrs. Gibault, please.
Merci beaucoup, Madame la Présidente.
Thank you very much indeed, Madam Chair. Yeah. Good afternoon to all of you. First of all, I should like to apologize to the interpreters. I will not at all read what I had prepared, because in fact what I want to do is to react to everything that I've been hearing since yesterday, and in so doing give you my own position on this. First of all, obviously, thanks are due to the European Commission for inviting me here. Let me make one thing clear. I'm not speaking as a French person, but as a European citizen, and obviously have no lessons to give to any other European country. Let me hasten to add that I have greatly appreciated the quality of the presentations we've heard so far, because Well, we haven't had sort of any extreme caricatures or controversial presentations. Everybody has recognized with a great deal of humility that no situation is far from perfect, that there's absolutely no way in which can really completely eradicate destitution, abandonment, and the legislation cannot solve everything. The only thing we do know is that inter-country adoption should remain side by side with national adoption or foster families or help to return to the country of origin according to the case should remain one of the alternatives to give children who are abandoned, who are orphans, a framework within which that child can develop and can have a future. In my capacity as a European Member of Parliament during the last legislature, together with Jean-Marie Cavada, who was the chair of the Commission on Civil Liberties, we fought a great deal against a very virulent movement led by a European Member of Parliament against home adoption, against inter-country adoption, and later with Commissioner Frattini and with Mr. Barrot, I went even further into this. Now, obviously, inter-country adoption is not it's not within the remit of the European Union, but protecting children is. And this is the reason why I struggle in favor of a European space, a common European space for adoption. In other words, an adoption that would not be considered as an inter-country adoption. So there's a whole lot of things to be done in this particular area. Now, that the Lisbon Treaty has just been ratified, we're going to have the President of Europe, we're going to have a Minister of Foreign Affairs in Europe, and we're all working towards building a so-called European identity, favoring, obviously, the free movement of students, of artists, of workers. We have a common area for judicial cooperation. We're all in favor of respecting cultural and religious diversity. So the time has come to see what we can do about a common space, a common European space for adoption. Faced with the proliferation of legislations in the matter, all kinds of international standards and rules on this, it is absolutely essential to develop cooperation among the administrations of the various member states so as to have mutual recognition of the adoption decisions that are made, because only the states that ultimately can guarantee the values and the regulations governing inter-country adoption. And there's one rule where the European Union is worth its salt. It's precisely in this area. Madame de Berger-Quiquion, Jean-Marie Cavada, and myself have already answered the question about what to do about Europe and adoption, because in 2008 we published a piece of work on inter-country adoption. Let me restate some of the things we said there. First of all, we have to put forward that every child must have an identity upon birth. This is a thing we already said back in 2008. And we must have a code of good practice for all member states, which would make it possible to simplify adoption procedures and also cut down the time is required to process the adoption applications. And this for the best interest of the child. You have to have a climate of trust also among member countries. The country of origin, whence the child comes from, must be kept abreast of what the development of that child's life is in the other European country where he's adopted, so the country of origin can be assured that the rights of the child who is adopted in another European country are fully complied with. And also, member states must be helped to cope with the disarray of all abandoned or orphaned children and facilitate their integration into the family of another European country whenever a domestic or home solution is no longer possible, as advocated by the International Convention for the Rights of the Child. And always recall that amongst the criteria for acceding to the European Union, there is the respect for fundamental rights, and indeed the Charter of the Rights of the Child is part and parcel of that. So all of us here must continue endeavoring to make sure that the legislations in force are adapted until such a time as Europe becomes a common space for adoption, and the most vulnerable children, whatever their ethnic origin or whatever the religion, that they all can aspire to having a family. I always say that you can judge pass judgment on the quality of a democracy, and I say this for France as well, by the way in which you deal with the most vulnerable people, people in asylums, in psychiatric hospitals, in prison, the elderly, the sick, and as long as vulnerable children are not really fully cared for, then I don't think that politicians are doing what they ought to be doing. And before concluding, let me go back to the case of Romania, because this is a particular case on which I've worked a great deal when I was a member of Parliament, the European Parliament, and I keep myself abreast of developments here. Let me draw your attention to a phenomenon which is taking on more and more importance, and which unfortunately stems from the policy that has been carried out over the past few years, which is now coming slowly towards its solution. Very many abandoned and orphan children are now coming of age, 18, no longer cared for by institutions. And so these abandoned children who become adults are no longer in the statistics. And so this is why the number of abandoned children is going down, even though it isn't really. What is even more alarming is that this figure does not take into account the tremendous listlessness of these children whose parents have left them, have migrated to Western Europe in search of a job. There's some 90,000, according to Romanian authorities, 350,000 children, according to UNICEF. So the institutions are really, they don't know how to cope with this. And so these children are not really considered to be disabled or retarded. These are young, very vulnerable teenagers, young adults, who haven't got any family relations and haven't got any serious professional qualifications, and they don't have any housing unit, no dwelling. So how can we keep our eyes shut, since we turn fundamental rights into one of our priorities? How long can we keep our eyes shut, faced with the situation within our midst? The health policy, the social policy, in the area of subsidiarity for every single member country, its budget and social policy comes under very close scrutiny. But let us not forget that the very first right of a child is the right to a family. And so we should promote European countries such as Romania and Bulgaria to undertake any and all possible actions that would make it possible to solve as quickly as possible the difficulties they encounter in reintegrating home adoption as one of the policies for child protection on their own territory. My very last words will be those of my son Jose. I adopted some 20 years ago. He wrote a short text for me to read out to you. He said, I never had childhood, or an early childhood. I was born at the age of 2.5 on a beach in Togo, in Lomé, after my eyes crossed yours on the steps to my orphanage, and I immediately understood that I had an anchorage, a point of reference, a bridge to the real world, and that I could, for the remaining of my life, for the rest of my life, rely upon you. Thank you very much.
Thank you very much, Mrs. Gibault, for these words. The next will continue with the results of the study carried out by the European Parliament that will be presented by Mrs. Raffaella Pregliasco from the Istituto degli Innocenti. Please, the floor is yours.
Thanks. Firstly, I want to thank the Council of Europe and the European Commission to giving us the opportunity to present this report that was awarded by the Istituto degli Innocenti from the European Parliament, and that the Istituto degli Innocenti realized with the help of with the collaboration of many European experts, and also with the collaboration of Child on Europe Network. Child on Europe is a network of childhood national observatories and centers. The main purpose of this report consists of proposing an updated comparative vision in the field of inter-country adoption at European level, in particular following an interdisciplinary perspective able to give adequate consideration both to social and legal aspects involved. In particular, the research showed two different levels of analysis. At an international level, we have a documentary analysis that is aimed to give a statistical profile of the phenomenon in the European Union countries, and then a review of international European instruments. At a national level, we have a comparative national survey that we have realized through the analysis of national legislative frameworks. The study led to some concrete proposals for the intervention of a European Union level and national policy makers, as well as representatives of civil society, directed to harmonize the different national rules and experiences and to create a European adoption system. For that purpose, a network of experts, 27 experts, coming from most of the European Union countries with specific knowledge of the subject, was entrusted with collecting the documents and data in the different member states and drawing the national reports using a format, a sort of questionnaire, drafted to help them in finalizing their work. Harmonizing the both qualitative and quantitative informations. For what concern the statistical aspects, the statistical profile of the phenomenon within Europe, the inquiry made it possible to underline that European Union receiving states accounted for over 40% of total inter-country adoption worldwide in 2004. 2004 is the year during which we managed to find comparable data. In the same year, the 9 European Union states of origin provided 3.3% of the children sent for international adoption. All of the states of origin now send primarily children to other European Union countries. On the other hand, most European Union receiving states take children mainly from non-European countries, and only Cyprus, Malta, and Italy took more than the 10% of international adoption they made from other European Union states. Moreover, the analysis put in evidence some general trends of the phenomenon, which show an initial rise in the number of international adoptions between 1998 and 2004, and a subsequent fall during the year 2004-2007 in the total number of intercountry adoptions, as I said. In particular, it could be underlined that the number of intercountry adoption worldwide grew substantially from the mid-50s, reaching a peak of over 45,000 in 2004, and in the next 3 years the numbers fell to 37,000, similar to the level in 2001. 3 European Union states, France, Spain, and Italy, have been among the top 5 receiving states for the last 15 years. While the data collected were interesting and they help us in giving a good enough framework of the statistical phenomenon within European Union countries, it is important that all the European Union countries take steps to encourage to keep accurate records of children sent or received with more detail than is found in most returns. An immediate step could be to support the current efforts by the Hague Convention to develop a common pattern of returns from all contracting states. For what concern no, the other one, no, the next. Okay. For what concerns the psychosocial and policy aspects, in the report, legislative choices taken both at international and national level have been viewed together with practices followed in the domestic experiences to verify if and to which extent the declaration of principles, the interpretations and the applications of legal rules are reflected in concrete measures adapted to the needs of an individual situation. In particular, it has to be underlined that the preparation work with prospective adoptive children is still scarcely developed in most European countries of origin, if compared with the preparation of prospective adoptive parents. Most countries of origin acknowledge the importance of preparation services for children, but they often lack the resources or knowledge to prepare the child for adoption in an adequate way, taking into account issues of child development. Moreover, with respect to matching, it seems there is still not a common set of clear-cut criteria or guidelines available for matching issues and procedures. From the child best interest perspective, it should be recommended that psychological expertise by clinical psychology or experts on child development is used to guarantee good match. So more research is needed on which decision rules are used in practice and how adequate these rules are at the moment. Finally, for what concerns the psychosocial aspects, we noticed that the number of adoption of special needs children grew substantially in those latest years, and probably they will continue to grow in the future. But at the moment, there is no consensus about special measures or policies in the European countries. Even if some countries have experience with campaign or protocols to better prepare the prospective adoptive parents for a special needs adoption. So it should be concluded that special needs adoption deserve more attention now and in the future, and therefore existing experiences and efforts should be combined to improve the awareness, the knowledge and practices. Finally, for what concerns the legislative and normative aspects taken into account in considering the research, a detailed national policy analysis has been carried out with the specific aims to find unifying elements in the legislation in place and the main question at stake in the different countries with regard to adoption procedure. Special attention has been given in particular on the rules about the competent authorities, those regulating the adopters and the adopted children's requirements and rights, the models adoption, the measure to react to the phenomenon of abuse, and so on. It has to be underlined that the differences made in the report among the European Union states' experiences makes it clear how deep some divergences are. And these differences can be extremely sharp. Both procedural aspects and national practices and services present intense diversities. And the role played by national legislators, courts, or competent administrative authorities is still a co-one. For what concerns recommendation that we could give as researchers to the European Parliament, we can say first that when all the persons involved in the adoption procedures have European citizenship, unitary solutions should be considered to ensure the direct recognition in a European country of decision concerning adoption made in another European Union country, whether or not the latter has ratified the 1993 Hague Inter-Country Adoption Convention, on condition, however, that its principles are accepted and the best interests of the child have been duly respected. So, to conclude, what we can say is that we must improve resources to ratify international convention, trying to enact new pieces of national legislation and to create new monitoring mechanisms. The most appropriate first instrument to achieve this result could be, for example, a specific European Union Parliament resolution with a view to create a European Union working group of experts in this field. We could say that at this point it seemed not necessary to think about a European adoption, strictly speaking, but for a sort of a Europeanization of adoption law in a broad sense that could guarantee at least a common frame of reference between all the European Union countries members. Thanks.
Thank you very much, Mrs. Preliasco, for these conclusions and recommendations. Next, I will give the floor to Mrs. Patrizia De Luca, who is the team leader in my unit in the Civil Justice Cooperation in the Directorate General Justice, Freedom and Security in the European Commission, and she has been charged of the study concerning adoptions. Please.
Thank you, Sala. Good afternoon, ladies and gentlemen. I should like to start with a few words about the background of the European Commission studies. In other words, why the European Commission decided to carry out a study on adoption procedure in the member states of the European Union. Protecting children, second slide, protecting children's rights is one of the European Union top priorities, as stated in Article 3 of the Treaty of the European Union, the new Treaty on European Union, which entered into force today. This aim is also recognized in Article 24 of the Charter of Fundamental Rights of the European Union, which states that in all actions relating to children, whether taken by public authorities or private institutions, the child's best interest must be a primary consideration. Already in July 2006, the Commission presented a communication towards an EU strategy on the rights of the child, which proposed a comprehensive strategy to safeguard children's rights effectively in all European Union policies and to support Member States' efforts in this field. One of the rights that children have is to be brought in a family environment, as clearly stated in the preamble to the United Nations Convention on the Rights of the Child. Hence, adoption is part of the picture. If the European Union wishes to protect and promote children's rights, it must pay more attention to the issue of adoption. However, at present, there is no common policy in this field. Indeed, adoption is specifically excluded from the scope of Council Regulation Brussels IIa, which relates to issue of parental responsibility, visiting rights and child abduction. We can, however, count on an important international legal framework for adoption, the 1993A Convention on Intercountry Adoption and the Council of Europe Convention, in particular the revised one. We have also to consider the United Nations Convention on the Rights of the Child and its principle of subsidiarity that has sometimes lent itself to uncertain interpretation. We can now affirm that, as recalled by the UNICEF in the 2007 statement on intercountry adoption, that intercountry adoption may be indeed the best solution for individual children who cannot be placed in a permanent family setting in their country of origin. Institutionalization should be considered as a last resort solution for a child without parental care. The principle of subsidiarity, and here I am quoting the Hague Conference on Private International Law, must be applied realistically. The Hague Convention refers to possibility for placement of a child in the state of origin. It does not require that all possibility be exhausted. This would be unrealistic. It would be placed an unnecessary burden on authorities, and it may delay indefinitely the possibility of finding a permanent family home abroad for the child. The principle of the best interest of the child is the overriding principle in the Convention, not subsidiarity. Moreover, we should not forget that the Convention on the Rights of the Child is of a universal nature and therefore must also take into account the point of view of countries, Islamic, for example, which do not recognize the institution of adoption, or specific cases where children are separated from their parents by war or natural disaster. That said, we have to apply the general principle of the International Convention to the specific context of the European Union. We cannot deny that the European Union has its own particular background, and that adoption between member states does not have the same implication as an adoption involving third countries. The European Union is an integrated area with no internal borders. Member states of the European Union share common values. They are working together to establish a common area of justice, freedom and security based on the principle of mutual trust. Closer cooperation on adoption between the member states might be regarded as one of the inevitable consequences of the free movement of citizens and the gradual emergence of a European judicial culture built on the diversity of legal system, the promotion of citizens' rights, and unity through European law. According to a recent Eurobarometer survey, most citizens want the European Union to take an active role with respect to adoption between member states. The figures vary from one member state to another, with the highest figures in France and in Italy, 87%. Nevertheless, on average, the number of citizens in favor of EU action in this field is very high, 76%. Moreover, in recent years, the European Commission has received several complaints from citizens and associations on the issue of adoption between member states, explicitly asking for action on the matter. One of those citizens is here today to tell us about her experience. So, briefly, the content of the study, we asked our contractor to produce a comparative analysis of the legislation in the 27 member states and to identify practical difficulties and problems encountered in this area by European citizens. Finally, we have asked the contractor to identify possible solutions to these problems. The study is divided into a legal analysis and an empirical analysis. The empirical analysis include, for instance, the number of decisions on domestic or inter-country adoption, the average length of the adoption procedure, the role of advisory service and family mediation in adoption procedure, etc. Moreover, a survey was conducted based on 500 interviews with lawyers, judges, social workers, adopted persons, association of adopted parents, and policy makers at national and the European level. I will stay short on the legal analysis because my colleague Raffaella Pregliasco has already given an overview. In general, I can say that the analysis of the legislation has identified a vast set of national solutions, sometimes presenting a high degree of difference one from the other, concerning, for instance, the role of the central authority, concerning the accredited bodies. For instance, we have 15 countries which have accredited bodies, and, but the division of competence between the central authorities and the accredited bodies is very different. The provision with regard to the prospective adopted parents are very different. For example, concerning the age, civil status, they may be single person, married couple, heterosexual or same-sex couple. Regarding the adoptability of the child, most EU member states require the consent of the biological parents. Only Italy requires the state of abandonment of the child. One problem which has been raised with the European Commission is the lack of recognition of adoption decision between member states. Theoretically, if a state is a member of the Hague Convention on Inter-Country Adoption, foreign adoption orders should be recognized automatically. In practice, this is not always the case, as is borne out by the complaints submitted by citizens to the European Commission. Okay, Sala, tell me that I have only 2 minutes, and the problem of recognition, I would like to invite the representative of the Central Authority of the French community in Belgium to explain in more detail to us this problem during the next debate. Concerning the empirical analysis, has shown that there is an interest for a possible EU action, the need for training courses for prospective adopted parents. There are complaints on the lack of training for people involved in the adoption process, critics to private adoption, because it is seen as a mean to circumventing the law against child trafficking, and the request of post-adoption service where this possibility does not exist. The shortcomings are the cost of adoption, excessive bureaucracy, duration of the procedure, disparity of case law, and incomplete or incorrect information about the child, especially regarding his health condition. Finally, to close, the policy option. What the European Union can do about this? So there are a certain number of possible policy options to be taken by the European Commission, which are more or less feasible in the current circumstances. For instance, creation of a European adoption agency. This could be a kind of super central authority whose task it would be to coordinate adoption procedure in Europe. This option could ensure equal treatment for all European citizens and the possibility to collect all relevant data. And the solution would probably allow for a certain harmonization of rules. The disadvantage of this solution is the time required to set up a new agency and the cost involved. Moreover, in matters relating to family law, the unanimity of all member states is required. Second option, recognition of certificate of eligibility of prospective adopted parents and recognition of adoption decision in all member states. This could be done via direct recognition or by means of a simplified procedure. Third option, creation of EU common adoption certificates. Rather than having simple recognition, one solution may be to create a common adoption certificate for the eligibility of the parents, for example, or the recognition of adoption decrees issued in other member states. A single European procedure could be developed for the delivery of the certificates. Fourth option, a register of children awaiting adoption. This European Register of Children would list children eligible for adoption at the European level, so all these children will then have an equal opportunity to find a family in Europe. 5, the child rights to a family. Although this core principle is sometimes not uniformly interpreted at international level, it should definitely be so at European level. By making the child's right to a family an absolute principle, it will always be possible to act in the child's best interest, giving a preference to the possibility of a European adoption over institutionalization or long-term foster care in the child country of origin. A shared interpretation of the principle of subsidiarity would be most welcome. 6, harmonization of national legislation on the basis of the existing convention. The member states of the European Union could be encouraged to harmonize their legislation, at least on a number of specific issues. And the correct implementation of the Hague Convention and the ratification of the 2008 Council of Europe Convention could play also an important role in this respect. Last possibility, of course, is to do nothing, apart from general adherence to the principles stated in the International Convention. However, personally, I think that this option is not appropriate because the majority of European citizens want the European Union to intervene, and the current situation undermines some of their fundamental rights. Thank you for your attention.
you. Thank you, Patrizia, for presenting what our consultant found out in the study, in the comparative study for the 27 member states. Then we have the opportunity to listen the experiences of Mrs. Brigitta Toth as a European adoptive mother. And she's a European citizen. She has here a title expert, so she's certainly expert in her own case. So please, the floor is yours.
Thank you very much. And I'm very pleased to see that Patrizia reflected on lots of the issues which we came across through our personal experience. So we're very pleased that the EU legacy makers are aware of what is needed across Europe. As we heard this morning, the importance of the Hague Convention adoption is clear. However, it does not cover all scenarios, and therefore it is essential that not Hague Convention adoption policies in individual countries are constantly reviewed and updated. And this was also mentioned by Claire Gibault earlier. Additionally, I'm not sure that the experience we've faced is unique to the UK, or whether the same problems exist elsewhere in Europe. I'm a Hungarian citizen and I lived in London for 13 years. My husband is British. Toby, our adopted son, is the son of my cousin. I'm a very happy adoptive parent with a very bitter experience and memory of the process. In January 2008, my cousin in Hungary was to give birth and decided to relinquish her unborn child for adoption. Fortunately, by that time, we had previously started a UK domestic adoption process by choice and not through infertility. And therefore, we weren't desperate, or we weren't upset as previously prospective adopters were referred to. Our assessment was almost complete, but we had to change the process from a domestic adoption procedure to an inter-country adoption procedure, and we were told that it is impossible to complete the assessment to be ready for Toby's birth. In March, to prevent Toby from being put into care and to keep him within the extended family, we decided to go to Hungary and adopt him. We sought legal advice in the UK prior to his birth, and we were suggested not to do a Hague Convention adoption. The only way to proceed with that was to move back to Hungary, where I'm still a citizen, and to go through a Hungarian kinship adoption process as a single mother with the supportive statement of my husband. Toby was born on the 21st of March, and we traveled to Hungary a week later and went through all the various checks that were prepared prior to arrival to Hungary. And to be able to pick up Toby straight from hospital, we had to act according to the Hungarian legislation. The initial paperwork, such as the birth mother statement and consent, and our statements had to be officially registered. And then the baby was released from hospital at 10 days old on the 31st of March, and we were able to start a fairly normal family life. We had weekly visits from the social workers and a health visitor and health checkups by a doctor every 2 weeks, additionally to the home assessment done by Hungarian social services. Reports were sent to the local child protection agency on us, and they also visited us and filed further reports on our ability to parent this child. All legal requirements completed in accordance with the Hungarian adoption legislation. In the first 4 weeks, I was acting as the legal guardian for the child. Then further statements were taken, and the guardianship order was replaced with an adoption placement, followed by the final adoption order in early June. During the process, it's very important to highlight that the birth mother was given several opportunities to change her mind, and if she decided to take the child back and give the opportunity to be brought up within the birth family, she was given the opportunity. Hungarian social services, after this, encouraged us to live a normal family life, and no further visits or intervention was necessary. The UK experience, unfortunately, wasn't straightforward. because our assessment was still not complete. I had to fly back several times to be able to finish the UK process, and then we were recommended as prospective inter-country adopters by an adoption panel. Then they made a recommendation, and the further body issued an actual approval. This, however, was still not valid across Europe until the DCSF, the central authority in the UK, checked whatever exactly we didn't know, or we don't know until this day. And then they issued 4 months later a certificate eligibility to adopt. I like to point out that by then, Toby was with us for 4 or 5 months. So we were still not eligible to adopt, but we were caring for him. The adoption panel was in May in the UK, and then the certificate was only issued in September, 4 months later. It was already addressed yesterday and today, how every day and month is too long for a child in the need to wait. Toby was issued a passport and a new Hungarian birth certificate, which stated me as his mother. I became the only legal representative and the mother of Toby under Hungarian law. June to September 2008, we were forced to stay in Hungary as the UK authority did not allow Toby and me to enter into the UK. And that is a clear example of how one of the member states issued an adoption final order, and it was not recognized by the other member state. I risked my home in the UK, my job, accumulated debts paying for the second life in Hungary, because we were never warned how costly and how luxurious is a European inter-country adoption considered to be. Our life as a complete family was greatly compromised due to the fact that my husband was working in the UK and I was stranded in Hungary with our child. The restriction of freedom of movement, therefore the Amsterdam Treaty, was fairly violated, and this whole saga was surely not the best interest of the child. Under normal circumstances, a child would have been allowed to travel with his or her parent as soon as an EU passport is issued in their name. UK immigration law states that visa is not required even for an adopted child. However, the certificate of eligibility is necessary when entering the UK. This again could have been avoided with a certificate eligibility which is recognized across the European Union. A child who is adopted and a parent who adopted him lose their freedom of movement rights when attempting to enter the UK. September till November, it was just towards the end of our journey, UK authorities finally issued the certificate of eligibility allowing us to return to the UK, but we were still not allowed to travel back without my husband coming to pick us up. Although we were followed a non-Hague Convention adoption, the procedure the DCSF followed was in accordance to those rules. They sent documents to the responsible Hungarian ministry, and they wanted the Hungarian ministry to give me and Toby a permission to travel in the UK without my husband. The Hungarian ministry was simply not willing to comment on this, since they do not have the power to restrict a mother and a child's EU freedom of movement. Later, the UK court was also considering to track down the birth mother for a new consent 19 months after the original was given, although the Hungarian proceedings were completed. Then the DCSF forced us to readopt Toby in the UK with continuous social workers' visits and intervention. Full legal adoption of Toby in the UK was finally only recognized by the UK High Court on the 4th of November 2009. The Hague Convention adoption was not suitable for us because, according to the Hague Convention rules, we would have Toby should have gone into care until the paperwork was completed. And I'm certain that this would have not been the best interest of the child. Authorities in the state of origin and the receiving country must exchange completed assessment of adopters and the child before adoption. These were Article 17 and Article 29 previously referred to earlier. So waiting for this lengthy procedure where the UK process and would have taken 12 to 18 months would have resulted Toby to be cared for in an institution during that time or adopted to a non-family member. One assessment and one approval should be valid across Europe, and one adoption order should be mutually recognized. The problem that the UK recognizes foreign adoptions from something called the designated list. These countries are all Commonwealth countries, including interesting countries such as Zimbabwe, Malawi, Sri Lanka, Tonga, Nigeria. Most of them are not even signatories of the Hague Convention adoption, and other countries include France, Germany, Italy, Sweden, and Austria. But they do not recognize adoption from former Eastern European countries, such as Hungary, Poland, Czech Republic, Slovakia, etc. This list of designated countries currently being reviewed under the provision of the Adoption and Children Act 2002, but this is the message on the UK inter-country adoption website for several years now. It is apparent that the 2004 accession countries, the so-called Eastern Bloc, are not on this list. Personally, I find it difficult to imagine that the membership criteria did not cover legal obligations related to family law. If a divorce is valid across the European Union, why isn't an adoption order? And finally, the conclusion is that the current UK legislation is not in the best interest of the child, as the current process is unfair, unclear, difficult to navigate, and expensive. I personally consider to adopt Roma children from Hungary who are not wanted domestically, as was mentioned yesterday by Ms. Herzog. But the cost and the bad experience I went through, according to the UK inter-country adoption process, prevents me from doing so. There are always children in need for a home, and there are always people waiting to be allowed to adopt. What is going wrong? Where and when? If an IVF treatment is subsidized and widely available through the national health services across Europe, then why inter-country or cross-European adoption is treated as a luxury costing £8,000 to £10,000 in a case of Hungary? In fact, we were constantly asked and pestered why do we want to adopt rather than going through IVF. Surely this is not the right approach when somebody just decides wanting to give a home for a child. In Europe, 2009, there are families who are connected to different member states by relatives. These relatives should have the possibility to be informed and accommodate a child within the extended family, should they choose so. The Hague Convention of Adoption has no subsection for kinship adoption, and this needs attention. It is the best interest of the child to stay within the extended family, i.e. families abroad, or to be kept within the country. If the UK identifies a child, for example, in need of a placement, they search for an extended family, sometimes even worldwide, and fast-track the placement should they find someone suitable and willing to take this child in. This is not possible for Europeans within the scope of the Hague Convention adoption. We would like to see an EU centralized agency or a working group to be set up to advise adopters, oversee and unify processes across Europe, and prepare a mutual recognition process to be implemented. Thank you very much.
Thank you very much, Mrs. Todd, about sharing with us your experiences. We will have now 15 minutes for discussion. I will open the floor for any comments or views on the need of the European adoption policy, on the options or the possible options for such a policy. You have heard about the different possibilities or different requests by our panelists. If you have opinions on those, please be free. You are also able to make questions still to the panelists. I would ask you to keep your interventions concise. I will take 3 questions or comments and then allow, if they are for the panelists, allow them to reply. And I have here first gentleman there, the lady there, and the gentleman there. And these are the first three ones, so please.
Vielen Dank, Frau Vorsitzende. Ich möchte mich ganz...
Thank you, Chairman. I'd like to thank the Commission. My name is Thomas Klippstein from the German Federal Ministry of Justice. I'd like to thank the Commission and the Council of Europe for having set up this meeting here and for giving us the opportunity to communicate with one another in a proper process. I've seen a lot of similarities, but there are some very great differences I've seen too. We've seen representatives of different agencies and countries saying that they had a different relationship with adoption law. Some people see adoption as a way of protecting children's rights. Others see it as an opportunity to engage in family planning, if I can put it that way. We've got 2 studies presented to us. I would like those studies to be published as soon as possible, because they do contain a great deal of material for discussion, not just of interest to people concerned, but also to legislators. And this is something which I'd like to present to our parliamentary committees as quickly as possible. Now, we've got nothing against having a horizontal policy to protect children. All the different areas of European policy should include protection of the child as well, where this is possible. And that should cover everything which has a closer or less close link to adoption. When it comes to the area of adoption law, we are a little bit reticent. We think that the Hague Convention has proved its worth, but we think it needs to be implemented fully and improved. And it's something which we've all been trying to do for several years, i.e. that we want to get as many countries to sign up to the Convention as possible. Above and beyond that, we are certainly open to any measures which would be below the level of the law. A common reference framework for Europe is something that we could probably support. I work in the Working Party, which looks at working on other measures for adoption. The problem is that we're not completely convinced that it really does represent progress, including this extra level of the law. 2 questions from me. Firstly, when does the Commission or the European Parliament think that we'll be able to access these studies? Secondly, when will there be concrete follow-up to those studies? What would it look like? Is this something which will be put before the European Parliament soon? Will there be resolutions adopted? And will the Commission be putting into operation proposals from the studies and making its own proposals for the action plan under the Stockholm programme? Thank you.
Thank you. Thank you for those questions. Then I had there in the middle the lady.
My name is Brigitte Siebert. I'm from the Central Authority for Intercountry Adoption of Northern Germany.
Sorry. I'm very sorry. It was behind you. Sorry.
Oui, je voudrais prendre la parole très rapidement au sujet.
To speak very rapidly about this convention in Belgium. Your name, please. In Belgium, we regularly have this problem. We have to face up to many European citizens living in Belgium, and they spend some time there, and I think this must happen in other countries too. But in view of the length of procedure of adoption, often we have to face the difficulties of somebody who's starting a procedure in one country and then who have to move into other countries more than once. And we find that it would be useful to set up a working party. I don't want to go into the details now, because we don't have much time, but I think that with regard to possible equivalences as far as safeguards are concerned, that the country of residence, which is the country which is recognised under the Hague Convention as the applicable law, and which is not nationality, then the country of residence, which has to provide guarantees with regard to people living in that country, and sometimes they may have started procedures in their own country of nationality contrary to the Hague Convention, which is accepted by some countries, but we think it would be very useful indeed to be able to set up a working party on that particular subject, on that particular question, to be able to simplify some procedures. The purpose being to respect the interest of the child and only having guarantees with regard to minimum conditions, because we know that some countries are much more strict than others with regard to compulsory preparation, and also the whole question of the various agreements. I think we should do this very soon. Thank you.
Thank you very much for these comments. And then I had here, please, gentlemen.
A very brief intervention. I'm Matthew Thorpe. I'm head of International Family Justice for England Wales. My intervention is directed only to Mrs. Toth. I just want to make it plain that we have a very sophisticated legislative adoption system in England Wales, very recently reformed. But, of course, there are always cases that can expose the weakness in the general system. And if Mrs. Toth would be so kind as to submit a memorandum of the difficulties she has encountered, I will get the International Committee and the officials working group concerned with international family law to look at the case and to see whether we couldn't make positive proposals for maybe extending the list of designated countries. Thank you.
Thank you very much.
Thank you very much for that. So on these three first comments and questions, I can reply to the direct question on when the studies will be available. I understand that the study of the European Parliament is already available on the website of the European Parliament, and the study launched by us from the Commission will be set to our website now after this conference. So after now presenting the study, the results publicly, we will put it in our website. So you should have it in there, let's say, as soon as possible. So that is there. On your second question on what kind of follow-up to the study, I can reply from the side of the European Commission. For our follow-up for the study is this conference. So the study was launched a couple of years ago. We wanted to use this conference to have a discussion to hear what is going on. For the next steps, I do not yet have any information to give. So that's here we are. We have still then, let's say, one round of the three questions. There's one gentleman just in the last row, and there's Mr. Duncan there, and and then there is the lady here. So we'll start there from the last row, please.
Hello, my name is Ciprian Buhuș, and I'm representing Romanian Authority for Adoption. And I want to do some remarks, but I will kindly ask you to speak Romanian.
Fine.
În primul rând, aș vrea să fac câteva precizări apropo de adopția internațională. Și are legătură cu faptul că, deși vorbim despre statutul juridic al copilului din adopție internațională.
Sorry, I don't get the interpretation. Do I get the English interpretation? What do I...
Acum?
Sì, in italiano sì.
Yes, it should be working now. Can you hear now? Can you hear? Had a technical problem, I'm afraid. Okay, perhaps we could just... Okay, could we perhaps just check this out?
Despre adopție, în principiu. Am vorbit despre statutul juridic al copilului.
Here we're talking about adoption. We're talking about the status of a child in adoption. And today we received some data when it came to children who live on the street, but that's not something which has anything to do with adoption. It's quite a different matter indeed. You also have children whose parents have gone abroad to work and the children have been left home alone. But that, again, has nothing to do with adoption. You see, each time when we talk about numbers, if we talk about Romania, then we don't talk about these things clearly. You have to talk about adoptable children. The important thing here is the role of the children and the families. Well, Romania is just one of those countries in which children can be adopted.
Thank you. Thank you for those views. Then, Mr. Duncan, please.
Thank you very much, Madam Chair. Just three brief comments. The first is to point out that the Hague Convention does contain within it some flexibility which allows groupings of states to reach agreements with a view to improving the operation of the Convention in their mutual arrangements. You'll find that in Article 39(2). So for any group, and not just the European Union, but any regional grouping of states who feel that they can improve some of the procedures within the Convention among themselves, there is the freedom to do so. That is within certain bounds, but for those who are interested, Article 39(2) of the Convention is relevant. Second point concerns the what has been said about what appears to be a problem within Europe, that in some cases adoptions that have been concluded under the Hague Convention and where a certificate under Article 23 has been issued declaring that the adoption is in conformity with the Convention. Apparently, from what I hear, some of those adoptions are not being recognized. Now, this is a serious problem because the automatic recognition of adoptions made under the Convention is a pillar of the Hague Convention. If it is not being respected, then the first thing to do is to find out why not. States only have one situation in which they may refuse an adoption concluded under the Convention, and that is where it is manifestly contrary to their public policy, taking account of the interests of the child. And I would simply say this, that non-recognition of an adoption is not a good sanction for dealing with breaches of the adoption process. So there is a real worry if that is happening, but the solution is not necessarily to go for an alternative system of recognition. It's to mend what is happening in relation to The Hague. The third point I would make is in relation to Mrs. Toth's tragic case, and first I want to give you my sympathies to have got caught up in this dreadful bureaucratic mess. I can understand the huge frustrations. The only thing I would say, because I don't know enough about the case, but just from what you have said to me and to the audience today, I would simply I would make a plea to everyone, please do not judge the Hague Convention on the basis of a case in which it appears to me that the Hague procedures may not have been properly applied. That's all I would say on that case. It would be improper for me to say more.
If I can just respond to that, I would never judge, because I think it's a very, very good start of point. But as you previously mentioned, it's not a perfect tool, and we all have to work together on improving it.
Thank you. Thank you for those remarks, which are really heard, taken into account from our side. I had then the third person, please.
Thank you. Buongiorno a tutti voi qui presenti.
I am Mirabella, and I am a street child, and I came from Romania when I was 14 years old. So I would like to introduce myself here. I'd like to stand up and say, because as we know the situation about the orphanages in Romania, and it's better to living in a family. But I have to say that I'm coming here now to put to you, ladies and gentlemen, to tell you about the situation of children who are living in orphanages, because very often I went back after 5 years. I went back to Romania because what I wanted to do is I wanted to see exactly what the situation was, to see whether it was the same as it was or whether it's changed now. Well, I realized that the situation of orphanages in Romania is exactly what it was when I left. Those children whom I had left behind in the orphanage, I met them again, but of course they're bigger now, they've grown up, but they were crying and they said, please, please do something for us, please find us a family to go to, please. Now here I'm coming to you today because I want to tell you what those children wanted. They want to be adopted. They want to have a possibility of living and to have a kind of a peaceful life. This proposal, well, what I want to say today is I am trying to help these poor creatures because they are really almost like being wiped out. They almost like don't exist because these children today, they are still living in the orphanage, and I mean, I am trying to be their spokesperson. Today, I have come to you today. I would just like to remind you of what they have to say. I'd like to speak on their behalf because they have no means to be heard except through the words I'm addressing to you today. And I think that we should try to give them a family. We should try to listen to what they have to say because these children are asking for families. Thank you.
Thank you. Thank you for that last opinion. And with this, I am closing the discussion under this session. I'm thanking profoundly for our panelists for bringing to us their views on the issue of the European adoption policy. I'm thanking the members from the audience for their comments. Now we are using half a minute to change the table, and we'll go to the last part, conclusions and recommendations. So please don't go away. It is just the table changing, and then we'll continue. Yes. Which side? Yes, that's exactly just the net. So we'll go ahead when we have Mr. Wilson. I'll open and we'll. Dear participants, could you please take your seats? We are going over to the session 7, conclusions and remarks.
I'm Tina Friedrich. I'm a journalist.
Ladies and gentlemen, if you stay in the room, please take your seats. Thank you. So we are going over to after very fruitful panels, our discussions that were sometimes quite short, but still important in the full plenary, to the conclusions and recommendations. And we have had as a general rapporteur Mrs. Rosemary Horgan, who has followed the 2 days and will now make us a summary, make us some concluding remarks and recommendations. So please.
First of all, I would like to express my thanks to the European Commission and the Council of Europe for organising this event, because it's been wonderful to hear the exchange of views over the last 2 days here in Strasbourg. And I'm somewhat under the gun. I have 10 minutes, so I'm going to have to speak quite rapidly, so I hope you can keep up. Speakers have referred to a number of legally binding instruments adopted at both national and international level, safeguarding the rights of the child during the adoption process in order to ensure the best interests of the child. Particular attention was paid to the revised European Convention on Adoption of the Council of Europe, as well as to the 1993 Hague Convention on Inter-Country Adoption, in highlighting good practices which help to ensure the rights of children during this sensitive and emotional process. They noted that those instruments are adoption neutral. They neither encourage nor discourage adoption. The hierarchy of choices available to state parties for the care of children must respect the rights of the child. However, when adoption proceedings take place, they should always be in the best interests of the child. Participants unanimously agreed that accession to and ratification of both of these international instruments should be strongly encouraged. When ratified, they should be effectively and scrupulously implemented and monitored to set minimum standards for the further development of national legislation and policies. Only 3 ratifications are needed now for the revised convention, the European Convention on the Adoption of Children, to enter into force, and we certainly hope that this instrument becomes binding sooner rather than later. A number of participants have indicated that they are in the process of promulgating national legislation to implement both conventions to ensure that the best interests of the child are safeguarded. The revised adoption convention should even now have a resonance in national courts and has been referenced in adoption cases coming before the European Court of Human Rights, as we've heard. The importance of the role of both governmental and non-governmental institutions promoting children's rights and governmental monitoring mechanisms cannot be overemphasised. These institutions have a vital role in issuing guidelines for the implementation of adoption policies and procedures for professionals working with this area in accordance with relevant international norms. Clear processes and procedures should minimise unnecessary bureaucracy. International cooperation needs to be further developed to promote the exchange of information and experiences, to identify good practices, to support best practice standard setting and effective implementation, and to promote the development of national integrated strategies to develop and combat all forms of child trafficking. The Council of Europe and the European Commission could play a crucial role for the benefit of national forums following insights gained from this correspondence, and indeed build upon and publish research already undertaken. All professionals, in particular judges, psychologists, social workers and lawyers, who become involved with a child in contact with the judicial system, should receive appropriate information and opportunities for training in appropriate methods for interviewing a child. The issue of child adoption needs to be depoliticised by giving paramount consideration to the best interests of children rather than the political sensitivities of sending or receiving countries. Whether residential care, foster care, national or international adoption is the best solution for an individual child in need of a home must depend upon the specific facts presented in each case. The mature child's consent to adoption is now necessary. The interpretation of the child's wishes and best interest should be facilitated through child psychologists and other qualified professionals. It is vitally important that children's views are duly taken into account in all adoption proceedings. The awareness of all professionals working in this area should be raised in this respect. A multidisciplinary interaction between various professionals involved, including judges, lawyers, psychologists, social workers and others, in the area must be encouraged in order to give practical substance to the concept of the best interests of the child, their right to be heard and to articulate their views. Information conveyed to the child should be age appropriate and their psychological needs taken into account. There may be a role to appoint a guardian ad litem for the child in this regard. We have heard the encouraging experiences of members of the judiciary who consider it necessary to hear the child directly before making a decision on adoption. Participants noted divergence in practice and procedures on the requirements of the consent of unmarried fathers, notwithstanding the jurisprudence of the European Court of Human Rights. A lively debate on the possibility of joint adoption for same-sex couples also highlighted a divergence of views on this issue. The revised convention remains flexible on the topic. Everybody agreed that the best interests of the child should once again be the paramount interest guiding every decision on adoption. Every effort should be made to avoid discrimination, including discrimination based on ethnicity or disability of children. The severance of ties of filiation arising from full adoption brings into sharp focus the rights of siblings, parents and grandparents. The question was raised as to whether this represents a disproportionate effect of adoption. And as the discussion from the floor developed, it became clear that these issues may need to be further developed. The right to know one's origins and the importance of that to adopted persons became very clear through the testimony of several adult adopted persons. A number of persons spoke with great emotion about their personal experiences, which was very powerful and persuasive on this issue. The human need to complete their life stories and quest for identity was perceived as important to their psychological well-being. Questions surrounding the collection and storage of data and data protection might need to be reconsidered in the coming years. Participants are particularly grateful to the two judges of the European Court of Human Rights for their insights into the jurisprudence of the Court on adoption. It should be borne in mind that the revised Adoption Convention is an instrument of harmonisation, setting minimum standards. One would hope and expect indeed that state parties will continue to improve and raise national standards over time. Work continues on other international conventions promoting the rights of children and recalibrating the balance between the rights of children and of adults. The focus of the Hague Convention is to provide a framework for the process of inter-country adoption, which is aimed at protecting the best interests of the child by establishing a system for cooperation between contracting countries to prevent the abduction, sale and the trafficking of children. This gives practical expression to the international standards set out in the UN Convention on the Rights of the Child. States of origin and receiving states participated in formulating the Convention to ensure that the best adoption procedures acceptable to all contracting states. The Convention, like all legal instrument, is a framework document and by definition incomplete and imperfect. Cooperation and transparency are the key ingredients to improving its implementation. State parties must be vigilant in adherence to Convention obligations. Participants were encouraged to take an active part in the review process of this convention scheduled for 2010. Every country which engages in inter-country adoption should become a state party to the Hague Convention because it embodies best practice standards of regulating inter-country adoption, thereby protecting the rights of children in adoption situations. All states which are parties to the convention should, when dealing with non-contracting states, apply, as far as possible, the safeguards and procedures set out in the Hague Convention. The cooperative framework of the Hague Convention is based on an agreed division of responsibilities between states of origin and receiving states. The best interests of children in inter-country adoption are safeguarded by a number of principles. Firstly, establishing specific safeguards to ensure the adoptability of the child, ensuring that due consideration has been given to alternative permanent forms of care for the child in the country of origin, ensuring that the necessary consents have been knowingly and freely given after counselling, by regulating the financial aspects of the adoption, by accrediting and authorising adoption agencies, and by verifying the convention procedures are followed. Receiving states must ensure that the adoptive parents are eligible and suitable to adopt, and that they have been appropriately counselled, and that the child is allowed to enter and permanently reside in the state. The responsibilities of receiving states and states of origin are not mutually exclusive. States of origin and receiving states share the responsibility for developing the safeguards and procedures protecting the child's best interest. Receiving states should avoid placing pressure on states of origin and should help states of origin to improve their child protection systems. Central authorities have both national and international aspects to their functions, with general and case-specific elements. Attention is drawn to the Inter-Country Adoption Technical Assistance Programme, coordinated by the Hague Conference, which assists contracting states in developing the infrastructure and procedures required to meet international standards. Regulation through bilateral agreements may be a step in the right direction. However, there was general consensus that the 1993 Hague Convention is the gold standard. Cooperation and standardisation between central authorities is important and must be supported through training courses, exchange of best practices, etc. Central authorities may require financial support from the European Union. In accordance with the fundamental principles of the freedom of movement within the European Union, it is important that there should be mutual recognition of certificates of eligibility and suitability of prospective adoptive parents, and publication and circulation of adoption decisions. Finally, if I could announce 2 birthdays today. Firstly, Ms. Patrizia de Luca has a birthday. And secondly, the Lisbon Treaty. Thank you very much.
Thank you, Mrs. Horgan. It is not an easy task to make a concise overview on the 2 days intense discussions, but I think that was quite fair account of what has been discussed for these days, so thank you very much. This and a more detailed report on the discussions will be set to the website of the Council of Europe and European Commission later. So this, as a follow-up to this conference, you will see this. I think that we have also possibility to set those presentations of the speakers which have been made in written available in the web. So that is also for the audience later. From my side and from the side of the European Commission, a few final remarks before I'll give the floor then to the Director Jan Kleijsen from the side of the Council of Europe. It was just mentioned, indeed, the entry into the force today of the Treaty of Lisbon reinforces importance of the principles included to the Charter of Fundamental Rights of the Union. A first consideration is that the promotion and protection of the rights of the child must continue to be a priority for all Commission and European Union actions. In particular, in the matter of adoption, the best interests of the child must be the primary concern. The European Union will continue its action to prevent child trafficking and the improper financial gain in adoption procedures. On the other hand, the right of the child to a family life should be recognized without hesitations at the European level. We consider it essential to promote largely the accession to the 1993 Hague Convention of Inter-Country Adoption. Already 26 out of the 27 Union member states are parties to this convention, and we would urge the remaining one to accede in the future too. Furthermore, we have included the 1993 Convention to the international framework that is important for the candidate countries of the European Union. And finally, we promote that convention also for all third countries in our external relations in order to rely on a common international legal framework. So this is our constant policy. But it's clear that not only the accession to the convention is important, but the fact that it has to be properly implemented. This consideration has a special importance for the member states of the Union, whose legislation on adoption present is and shows diversities, as we heard. The European Union, that is since 2007 a full member of the Hague Conference on Private International Law, can play in this regard a coordination role, even if the Union itself is not a party to the adoption convention. Also, the cooperation between central authorities of the member states throughout every step of the adoption proceedings should be supported by the Union by financing training courses and facilitating the exchange of best practices within our financing instruments and financing programs. In the context of the Union, which is an economic and political integrated area without internal borders, which is developing into an area of freedom, security and justice, where the citizens enjoy the freedom of movement, have the possibility to live and work in other member states. Also, the principle of subsidiarity in the adoption procedures could be interpreted in a uniform and consistent way, meaning that when the biological family unity cannot be preserved and the adoption of the child in his or her country of origin is not possible, international adoption should be considered in the light of the UNICEF position. The best solution in the case-by-case basis allow the child to grow in the permanent family environment. As the complete harmonization of the substantive laws on adoption is currently not a realistic option, we encourage the ratification by our member states of the revised Council of Europe Convention on Adoption. It offers already a common set of principles to be respected by the member states in their legislation and practices concerning adoption. In this context, we welcome the good progress and example shown by Spain and Netherlands in this context yesterday by the signature of the Council of Europe Convention. The respect of the fundamental principle of freedom of movement within the Union calls also for an EU action ensuring free circulation of the adoption decisions concerning EU citizens, ensuring the free circulation of European citizens, adopted or not. Adoption decrees issued by national courts or administrative bodies should circulate freely in Europe. Also, the mutual recognition of certificates of eligibility or suitability for prospective adoptive parents could be taken into account in order not to harm the freedom of movement of the European citizens. I thank you all for your important contributions through the discussions in this conference. These feed in to the consideration on how to effectively promote the best interest in the child of the Union. So thank you for our side very much. Please.
Thank you, Sarah. Good evening, everyone. I had the pleasure to address about a third of you last night whilst waiting for the other two-thirds that unfortunately did not make it to the reception in time. And once more, I would like to apologize for the logistical difficulties you had. I understand, however, that you did make it finally and that you also had a chance to enjoy the Christmas market. As the last speaker of the conference, I think I have to obey at least 3 commandments, namely that I shall not repeat the excellent conclusions of the General Rapporteur, that I shall not be too long, and that I shall not forget to thank anyone. So I'll try to be guided by the best interest of the conference participants. The conference, as you will have seen from the list of participants, was very much what I think today's jargon would describe as a multi-stakeholder event. We had often very senior level representatives from international organizations, national authorities, the legal profession, academia, civil society, and last but certainly not least, persons with personal experience of the subject at hand. I would like to thank all of them. In particular, I must say the last category, because I realize how difficult it can be, how must be, to speak about one's emotions, one's personal experience, instead of speaking about an academic or a professional subject. So I very much admire those that were able and willing to share with us the experiences they went through. It's sometimes very painful, very difficult, because I thought they were, and I think we can all agree that they were particularly enlightening, because that's ultimately what all this discussion is about, real people. I would also like, of course, before I forget, the interpreters who enabled us to work in 7 languages. I know. Very, very many thanks to them. For us, the triggering event for this conference, as you will have gathered, was the adoption by our Committee of Ministers, this is for the Council of Europe side, of the revised Council of Europe Convention on Adoption. The formal signature last night by two additional states gave, I think, an extra cachet to that theme. We're very happy that the European Court of Human Rights has already referred to the text as a common European standard, and we hope that when coming home, all of you will encourage, where possible, your authorities to follow suit. We will, as was said, already make the conclusions of this conference widely available, and I would strongly encourage you to do the same. Next year, just to let you know what we'll be doing next year, the Council of Europe will start work on a comprehensive legal instrument dealing with the rights of children and parental responsibilities, so very much building on the issues that we were discussing during this conference. It was also clear that from one day discussion on national and another day on international adoption, that there are many common questions that were raised, and we will consider, together with our partners, the creation of an interagency working group or interagency contact to see how we can tackle together these issues that are of interest to both national and international adoption. Once more, I'd like to thank Sala and the European Commission for their support in making this joint event possible, and to all the participants, of course, everyone who was a panelist, chair, but particularly all of you who came here to Strasbourg. I wish you all a safe trip home. Stay in touch, and hope to see you again soon. Thank you.
Thank you very much.